I turn it to Bob Barr to take you through the miscellaneous post-patent provisions and supplemental examination.
Hi, good morning. I'm here to speak about the miscellaneous post-patent provisions and supplemental examination. These miscellaneous provisions primarily concern two provisions. One is for statements concerning patent owner claim scope statements, and the second is an ex parte reexamination estoppel provision. These statutory provisions permit the public to submit certain patent owner statements and additional information which bear on the scope of a claim. These rules are designed to basically facilitate the prompt entry of these statements into the file of a patent if they're appropriate, and to otherwise conserve resources. The patent owner statements may be submitted if the statement was filed in a proceeding before a federal court or the office, and the patent owner took a position on the scope of any claim in the patent. That's the statutory provision. And the patent owner statements made outside of a federal court or office proceeding, these, however, are not eligible for submission. So if you simply get a statement from a patentee in a letter to a accused infringer, that would not be the type of statement that's eligible to be filed in the file of a patent. This provision, if it's by a third party, it has to explain how any prior art or patent owner statement and the additional information are applied to at least one claim in the patent. We also provided for, by rule, if it's being submitted by a patent owner, the patent owner has the option of explaining how these prior art or the patent owner statements and any additional information, they don't obviate or they don't overcome the patentability of the claim. Namely, they can explain why their claims are still patentable if the patent owner chooses to do so. We do have a requirement for these statements that there be basically that we know that there's been at least an attempt of service on the patent owner, so we won't enter these submissions into the file of a patent unless there's proof of service or proof that a bona fide attempt has been made to serve the patent owner. We do this because, unlike a pending application where an applicant might be looking in PAIR to see the status of it and is getting office actions from the office, for a issued patent, usually we don't expect patentees to continually monitor the file of the case and to take care of what's happening, and also in the office. We're not generally issuing office actions or doing any correspondence in patent files. Also here, the third-party submission can be made anonymously. That's provided for by statute. Now, how will we use this? The examiner will not use this submitted statement or additional information when deciding the request for ex parte reexamination. The way the statute is written, it says that the statement shall not be used by the office for any purpose other than to determine the proper meaning of a patent claim in a proceeding that's ordered or instituted under ex parte reexamination, inter partes review, or post-grant review. So during the decision whether or not to order reexamination, examiners will use the broadest reasonable interpretation standard at this point. As I indicated, the examiner will consider these statements and additional information after any ex parte reexamination has been ordered, and will only do so, though, to determine the proper meaning of the claim scope. We don't really view this as changing the general broadest reasonable interpretation standard. What we think that this statement will have a greater impact on is to either rebut or preempt any arguments by a patent owner that their claim has a different scope than they have otherwise stated in a proceeding before the office or in court. Changing over to reexamination, there's a provision that indicates that a petitioner in a post-grant review or an inter partes review, if they request review of a claim of a patent and it results in a final decision, that person cannot request or maintain with respect to any claim that or ground that they raised or recently raised in the proceeding, they can't maintain a USPTO reexamination proceeding. So for that reason, we want any request for ex parte reexamination to have a certification that the requester is not stopped from requesting ex parte reexamination, and information sufficient to identify the real party in interest so that we can identify if a ex parte reexamination is not permitted to be, if that party is not allowed to maintain an ex parte reexamination. Moving over to supplemental examination, we have the following goals in implementing this provision. First, the primary goal is to provide patentees with an alternative to litigating over inequitable conduct allegations. That's basically the primary purpose of this provision, is to give patentees an option with respect to inequitable conduct issues. Second is we wanted to create a process that allows completion of the supplemental examination within the 3-month statutory time frame and prompt resolution of any ex parte reexamination that has to occur. Finally, for internal processing purposes, we wanted to avoid a post-patent process that involves large submissions of unexplained documents, something like what we have for current IDS practice during application examination. The provision for supplemental examination is 35 U.S.C. 257, and it provides that a patent owner may request supplemental examination of a patent to consider, reconsider, or correct information believed to be relevant to the patent. And what burden puts on the office is that within 3 months from the filing date of this request, we have to decide whether any of the items of information submitted with the request raise a substantial new question of patentability. Why would the patentee want to request supplemental examination? Is there's a certain inequitable conduct immunization. Basically, the information that's submitted during the supplemental examination can't be the basis for rendering a patent unenforceable, except that this provision or this immunity doesn't apply to allegations pled in a civil action or a certain notice to a patentee before the date of the request for supplemental examination, and unless the supplemental examination and any resulting ex parte reexam is completed before the civil action is brought. So as you can see from this, the patentee has a great interest in ensuring that this process is concluded as promptly as possible. Now, one provision is that supplemental examination can only be requested by the patent owner, so there's no third-party request for supplemental examination. Also, a third party cannot participate in a supplemental examination. The large item is that we need, for a request requirement, is we need a list, of course, not surprisingly, identifying the items of information on which the request is based and a publication date of that information if applicable. For this supplemental examination, the information is not limited to patents and printed publications, like reexaminations limited to patents and printed publications. Instead, it can be any information believed to be relevant to the patent. For example, it could be information concerning a potential on-sale bar or that type of information. What do we want? We want a statement that identifies each item of information and explains why consideration or reconsideration is being requested or how incorrect information is being corrected. We want an identification of each aspect of the patent for which supplemental examination is requested. With respect to claims that have means plus function limitations, we want to know what the structure, material, or acts in the specification are that correspond to each means or step plus function element in that claim. For identification of each issue of patentability raised, we want an explanation of the bottom line is what aspects of the patent are being reviewed, what issues are raised by the information, and how the items of information are relevant to each aspect of the patent that's identified for review. Some of the more mechanical requirements is that we need a copy of each listed item of information, except we don't require copies of U.S. patents and U.S. patent application publications. But also, if we also want an English language translation of the pertinent parts of any non-English language documents. And we also need a summary of the relevant portions of any submitted documents other than the request itself. That's over 50 pages in length. We have here a requirement that the request itself be limited to no more than 10 items of information. We also have, though, a provision that you can file more than one request for supplemental examination of the same patent. The reason for this is that, as I discussed earlier, it's in the patentee's interest that we promptly clear up any IC issues and that we do these requests within 3 months and we resolve any resulting reexaminations promptly. So we want to create a process that works promptly, not just for the individual patentee, but for all patentees, so we can conclude all of these supplemental examinations very promptly. There are other provisions in that there's no amendment to the patent during the supplemental examination proceeding. The supplemental examination proceeding itself, it's simply the patentee submits this information and the office decides whether there is or is not a substantial new question of patentability, so there's no provision for amendments during this phase. If a SNQ is found, then if ex parte reexamination is ordered, then an amendment could be filed during that reexamination proceeding after the initial office action. How will we conclude the supplemental examination? We will conclude with a certificate. We plan to issue them electronically, and the certificate will indicate whether any of the items raises a substantial new question of patentability. If a substantial new question of patentability is raised by one or more items of information, then ex parte reexamination is ordered. However, if no new substantial question of patentability is raised, then we don't order ex parte reexam and we return the reexamination fee portion of the fees that are required for a request for supplemental examination. What happens after conclusion or after if we order ex parte reexamination, then the normal ex parte reexamination statute and regulations govern, except that the patent owner doesn't have the right to file a patent owner statement, and also the reexamination is not limited to patents and printed publications. Since the patentee could bring any items of information to our attention, the reexamination is not limited the way that normal ex parte reexamination is limited. Now, another item in the conduct of proceedings, if there's a provision of law that says if we become aware that a material fraud, that there was a material fraud in the office, that we are required to bring this information to the attention of the U.S. Attorney General. We're also authorized to take other actions such as possible enrollment and discipline action. However, before everybody gets really scared, I want to let you know that we really regard material fraud to be narrower in scope than inequitable conduct. So it's not every instance that might be raised as an allegation of inequitable conduct. That would not be what we view as material fraud. The fee methodology, this takes a little bit to explain. We have used what we call our cost recovery provisions to initially set the fees for this. This is Section 41D2. This provision exists, I'd say, before the AIA, and it was carried over into the AIA. It's the provision we use generally to set fees for new services when the fee amount's not specified in the statute. And basically what it says is that we have to recover the cost. We have to set the fee at an amount that recovers the average cost to us of the process. And it's a provision we've used in the past, be it not terribly accurately, to set fees for reexamination in the past, the 18-month publication fee, and even the RCE fee. Now, Section 10, which came into being in the AIA, gives the office greater authority over setting fees. For that, we get to set fees so that all the patent fees, if you saw the large scales in the earlier slides, so that all the patent fees equal all of our anticipated costs. We can't really use that effectively for this provision because there are some extra administrative processes that we have to go through. We have to have a PPAC hearing, a PPAC report, and there's also a congressional comment period. So we estimate that that process is going to take about 17 months. The supplemental examination process has to be up and running in 12 months. So we have to rely upon our pre-existing authority to just set fees on an activity-by-activity basis, and that's what we used for the supplemental examination. Now, specifically, the closest proxy we have in existing processes to supplemental examination is ex parte re-exam. And we've conducted a ABI analysis. We've done that over the years, and we've suspected these were our costs, but we did a more thorough analysis to confirm the cost of ex parte re-exam, and then use those costs as a basis to estimate what our cost of supplemental examination and any resulting ex parte re-examination would be. And basically, this is what we came to for our estimated costs, and thus the filing fee for a request for supplemental examination and a re-examination fee if it's ordered as a result. And what we've done in the rules is we've provided that a request for supplemental examination has to include the payment of both fees. Why are we requiring all of the fees up front? If we provided for these fees to be paid in stages, that we do a supplemental exam, and then if we decide we need to order re-examination, we then send out a notice requiring the re-examination fee, that would take about 4 to 8 months between the date we determined that there's an SNQ and the date that all the fees were paid, if the patent owner paid them in a fairly timely manner. Also, if the patent owner doesn't want to pay the fees, it is problematic trying to get the fees from the patent owner in this re-examination process. So instead of dealing with that, we wanted to conclude this as promptly as possible, so we determined that we would require that these fees be paid up front. That way, since we have to decide the request within 3 months, we will return the fee to the patent owner if there's no SNQ. And that's similar to how ex parte re-examination works, where the fee is paid up front. If it's determined that there's no substantial question of patentability, then the bulk of the fee is returned to the patentee. Finally, since we are also proposing to adjust the fees for ex parte re-examination, you may ask, what in the statute requires you to adjust your ex parte re-examination fees? Well, the AIA doesn't specifically require us to adjust our ex parte re-examination fees, but when we did our ABI analysis and determined with a pretty good degree of precision what this process is costing us, then since we are required under Section 41D2 to set fees at a cost recovery level, it became clear that we needed to adjust this fee to be in compliance with that cost recovery mandate. And so that is why we have also included in this notice of proposed rulemaking a proposal to adjust our ex parte re-examination fees to be more in line with what that process costs to the office. Thank you.
So for those of you in the audience who have questions about either the citation of a patent owner statement in a patent file or a supplemental exam, please come to the microphone. And then for our webcast audience, please try to speak into the microphone. There was difficulty in the last session for our webcast audience to hear you. So please come forward. Questions on either? Yes, sir, on the left.
Just a quick question on the fees. Are we going to give a break to the small entity, or are we going to, in other words, the fee for a large entity will be a little larger and the small entity fee will be a little lower for these new fees that you just mentioned?
For the ex parte re-exam, not initially, but when these fees are set under Section 10, the current thinking is that they would get the small and micro reductions, at least for the patentees, when requested.
Yes, sir.
There used to be a section that I've written about 20 years ago, Rule 1.500, where a person could file and put into the file a prior art reference. There would be no re-exam, there would be no exam. It's just in there in case somebody does re-exam later. Is that still there?
Yes. It's very similar to the provisions I first spoke of, is the patent owner statements. The statute that provides for this provides for both the submission of patents and printed publications by a third party, and it was amended to add the patent owner statements. So those provisions are still there, and those will still be in the rule that a third party can just submit patents and printed publications into the file of a patent. And like you say, they just sit there unless we have an office proceeding, in which case we look at them.
Okay, thank you.
Yes, sir.
Yeah, supposing for supplemental examination, if a patent owner has more than 10 references that they seek to have reviewed, does it make sense to have the exam fee or the re-examination fee go along with each additional required supplemental examination fee of $5,000? Supposing you have 20 references, would it make sense to have the re-examination fee paid twice, even though conceivably we might be refunded if 3 exams were not
That would be, I mean, you can obviously submit that as a comment. That's something we've thought about somewhat, where our thinking was that if somebody had more than 10 documents they brought to our attention, that hopefully for them, not all 10 would raise a substantial new question of patentability, and they would judge which ones are, if you will, the best and put them in one request so that they would only get one reexamination rather than spread them out. It would be kind of surprising if you had that many documents that raised an SNQ. So I don't know that it's a practical problem as if the requests are set up judiciously.
Does the office consider, supposing the reexamination, the supplemental examination requests are submitted simultaneously, and there are, let's say, 2 separate requests, would the office consider them all together so that you could conceivably consider a possible obviousness combination between a reference and maybe one request and another request?
That's more of a implementation detail we hadn't thought of. I'm just going to say we would probably handle them in the most efficient process. If there were few enough and one examiner wasn't super busy, that person would probably get all of them. If there were a lot, we would have to spread them out.
But as it's contemplated now, you would have to pay that.
Yes, that's the proposal.
Examination fee for
yes.
each set of 10.
Yes.
Yes, sir, on the right.
Hi, I have a few questions. First of all, on the patent owner claim scope, is there any guidance on how claim scope is defined? Are you going to take inferential statements like the patent owner is likely not going to say the meaning of this term is X, but he's going to say this reference anticipates or this piece of this product infringes? Are you going to accept those sort of statements as being claim scope statements?
I don't think we've thought that much through yet on this.
Mostly it's inferential is what you get. I mean, a lot of claim construction.
I mean, it would, like you say, it would be, it depends on how attenuated it is. If you're just arguing about what a reference shows, that's probably not going to be claim scope. But if you're arguing about whether or not a particular element in a reference meets a particular limitation in a claim, that goes more to claim scope.
Because mostly a patent owner is going to say, you're infringing, this product's infringing. And because they're taking that position, you can read into that how the claim's interpreted.
True, but that's, these would be the statements that are actually made in court where it's imagined that they would have more focused questions directed at them. It wouldn't just be the initial letter from the patentee saying, hey, take a license.
Okay.
I want to remind everyone, when you speak and ask a question or give a comment, please speak into the microphone so the webcast audience can hear you.
Am I too far away? Is that better?
That's better. Closer to the mic.
Okay, I got a few questions or comments on supplemental examination. Did the Patent Office consider any other procedures besides this reexamination style? Because just in a proceeding, because in my experience from hearing this and reading the rules more carefully, it seems very onerous and very dangerous. What a patent owner is going to have to do is essentially provide a roadmap on how to attack your own patent, and I can't see a patent owner doing that. Particularly in light of what's happened since Therasense. There have been like 20 cases since Therasense, and inequitable conduct has been found once, and a lot of times they're being dismissed on the pleading. So it doesn't seem to me like it's going to be used as much as you guys are anticipating. I'm wondering if there's a less onerous way to do this.
To some extent, I'm going to agree with your second half first. Obviously, Therasense was decided while this was going on, and if Therasense had been decided 3 or 4 years ago, one wonders if this would have even been put into the bill. But it's there, and you're right that it could be that Therasense makes the need for supplemental examination go down. But I'm not going to say we considered other processes, in that the statute seems to contemplate a reexamination type proceeding, but we did consider all of the requirements, to have it or not have it, and exactly how much to have.
Okay.
I mean, for example, we did not include a requirement that the patentee explain why there's no SNQ. We didn't have a requirement that the applicant explain why their claims are patentable. We didn't put those types of requirements in. It was more just tell us, what's in the references, what's in your patent that you want us to look at, what's in this reference or this document that makes it of interest, and exactly what statutory basis are we thinking that this is relevant to.
Because how I've seen this done, usually not through supplemental examination, but through the typical ex parte reexamination, is you say, this third party alleges that this raises a substantial new question of patentability, this new reference that was never cited, but it doesn't because of X, Y, and Z, and that's it. I mean, it doesn't seem like that would be sufficient under your guidelines. And then what would happen then? If someone submits a submission that doesn't meet these onerous guidelines, are they going to get their immunization, as you call it, or no?
Well, I don't wish to characterize them as onerous, but if the request did not meet the requirements for a request for supplemental examination, it would not be given a filing date, and so you would be notified of why it didn't and then given an opportunity to fix it. And at that point, hopefully it would comply. We would make a decision on it, and after that it would have the immunization.
Okay, that's all I have. Thank you. Oh, one other thing. Just what is the status of the Rule 56 proposal? I guess there was a proposed rulemaking in July, and nothing has happened sort of since then.
Yes, I hate putting it like that because it's not so much that nothing has happened. We get the comments. We got quite a few, and not everybody asked for the same thing. So we are still in the process of evaluating, what of the many suggestions.
Okay, so there's been no final proposal.
Right, we haven't issued a final rule on it, but we are considering the comments.
Is there a timeline for that, or no?
There's really, I can't promise you a timeline because the AIA is sort of a must-do rulemaking, and so that gets the timeline.
We're going to try and clone Bob Barr.
Okay, thank you very much.
Thank you.
Do we have other questions from our audience? Commentary? Folks on the webcast, I'm waiting for your questions as well. One of the questions that I think has come up that we've heard about from the public so far when we've gone out and done speaking engagements that I'd like to talk about is to ask about the service requirements for the the citation of a patent owner statement versus the service requirements for the pre-issuance submission. Bob, you talked about the third party doesn't need to serve in the pre-issuance submission, but the third party would, or the submitter would need to make a service in the citation of a patent owner statement. Can you explain the difference on those service requirements?
Sure. Just so you know, in the third-party submissions in a pending application, we don't require service. Where we do require service for the post-patent submissions. You may ask yourselves whether or not we were being schizophrenic, but we actually had a reason for having two different approaches. For third-party submissions in a pending application, for a pending application, the applicant or their representative is probably monitoring the proceeding a little bit more closely than they are for the issued patents. Also, a concern we had when the third party submits, when we get a third-party submission, we really don't want to get into an argument over whether or not the service was appropriate or was proper. We'd rather keep the focus on whether or not the claims are patentable. So we wanted to have the procedural hurdles for that be as little as possible. Whereas for post-patent submissions, we don't really do anything with them except in the relatively rare situation where we have an office proceeding concerning the patent file. And also in the with respect to patents, the patentee is not monitoring the status of a patent as much as an applicant would be monitoring the status of an application during examination. So we think there it's more appropriate to have the third party serve the patent owner so the patent owner knows that something happened.
So, Bob, does the requirement for service mean actual service, or can the submitter do something less? Could they make a bona fide attempt at service?
Well, what we would like them to, at least make a bona fide attempt at service. We have correspondence addresses where things should be mailed to, and if patentees keep them updated, then it should be very easy to, receive service if there's any submission into the patent file.
So to comply with the bona fide part of that, what does that mean that the submitter has to do? Would a certificate of service be sufficient to say I served at the correspondence address and that would be sufficient for the office?
Yes.
Thank you. Other questions from commentary from the audience? Nothing yet on the webcast. Well, then, much to Bob's dismay, I am going to move on and ask some questions about supplemental examination. So I'd like to explore a little bit with you the standard for supplemental examination. So the standard to trigger it is a substantial new question of patentability. And we've seen that standard come up historically with ex parte reexamination. So when the office is judging a supplemental exam, well, the SNQ standard and all the precedent that the office has built for itself attach in the supplemental, or how is the office going to read the words substantial new question in a supplemental? Will it be different than an ex parte re-exam?
No, we believe it should be the same. If you'll note, during inter partes re-examination, it was changed into inter partes review, and for the next, actually right now, the standard for having a inter partes re-examination ordered is likely, or not more likely than not, but a reasonable likelihood of success. And so Congress changed that standard. Since Congress kept the same substantial new question of patentability standard in supplemental examination as it has in ex parte re-exam, we think that when Congress uses the same words, they mean the same standard, so that we take that as a signal that the standard should be the same.
Now, one of the places I noticed in your slide set also said that, we're going to generally limit our review of the supplemental examination request to the issues that the patentee raised. When you use those words generally, are you suggesting that the Patent Office itself might sua sponte, in looking at the items of information, come up with additional issues that the office might see?
We don't plan to look for additional issues in these supplemental examinations. However, if something hits the examiner that would be an appropriate ground of patentability to raise, then that generally is there to give some flexibility so that we could consider an issue that was not necessarily raised by the request. But generally, the plan is to not go beyond what the request tells us.
And then in terms of the number of items of information, you had mentioned that per supplemental examination, a patentee can raise 10 items, but if they want 11 or 12 or upwards, they would need to file a new supplemental examination request. What was the office thinking in limiting supplementals to 10 each, although you could file an unlimited number?
Well, the thinking was not to see how many supplemental examination requests we could get out of any patentee. The thought was that most inequitable conduct situations, they pertain to only a handful of documents. Generally, it's just one document. So we felt that if supplemental examination is being used for its intended purpose, namely to head off inequitable conduct claims, 10 should be sufficient for almost all patentees. But we wanted to have, if you will, a safety valve for patentees if it goes over 10, so that a patentee could bring more to our attention if they need to, but we would hope that the, for lack of a better word, run-of-the-mill supplemental examination request would be well under 10 documents.
How's the office going to handle, though, if we get multiple supplemental exams at the same time? Will they be routed to the same examiner? Could they go to different examiners?
Well, I would think that the plan would be mostly to route them to the same examiner if possible. Obviously, if there were a lot, we might have to give it to multiple examiners. And if there were any resulting re-examinations, hopefully there wouldn't be more than one. But if there were more than one, we could possibly merge them if that were the most efficient thing. It's just that we need to decide the request for supplemental examination within 3 months, and that's why we need them in manageable bites.
But if a patent owner wants to file multiple ones, there's nothing prohibiting them from bringing multiples at the same time.
That's correct. There's nothing that prohibits it.
Okay. So they can eventually get all the art that they want to have presented to the office presented.
Yes.
Does the office have any sort of situations that you may have heard about or have an understanding when a patentee is ever going to want to use a supplemental exam to bring these items of information to the office?
Well, obviously, the classic situation is when a patentee is, if you will, in licensing negotiations and information is brought to the patentee's attention. The patentee would probably want to bring that to our attention to head off any inequitable conduct challenge to that patent. Obviously, a request for supplemental examination has to be brought before any civil action to have an effect in that civil action, so it's something that has to be done in a timely manner.
I don't mean to dominate here, so anyone who would like to come up and ask questions or make a comment, please come up to the microphone. Oh, there we see somebody. On the right.
Follow-up question here. If I understand correctly, I heard that the office is just going to focus during the supplemental reexaminations on issues raised by the patentee in the request. And if that's so, doesn't that present a little bit of an inconsistency with the result of a supplemental examination immunizing the patentee against inequitable conduct for the each reference as a whole?
Well, remember, the immunization effect is with respect to the conduct, with respect to the information that it wasn't presented earlier. A supplemental examination doesn't make a later challenge to patentability. It doesn't take that off the table. And obviously, we don't want examiners to wear blinders when they do this. We don't want them to go chasing, down mouse holes, if you will. But we want them to have the flexibility to raise the issues they see, but not to have their focus be all over the place, but rather on the request itself.
Questions, comments from the audience? Again, on the right.
I'm not that tall, sorry. Are the requests for supplemental examinations going to the examiners in the CRU or to the examiners in the examining corps who originally examined the application?
The current thinking is it would be the CRU handling them. Obviously, workloads would dictate what we do.
Now, Bob, can we talk a little bit about fees? Everybody's pocketbooks are going to be affected by these supplemental examinations, and I'm curious. I saw on the slide it said that there's a document size fee for any non-patent literature that's submitted that's over 20 pages. Can you explain why do you first make the distinction between patent and non-patent literature, and second, why do you need the additional fee for non-patent literature?
Well, the first answer is with respect to the type of document. The reason why we didn't have the fee applied to patent-type documents is that patent documents tend to come in a specified format, and they're a little bit more digestible to examiners. So we felt that and also it's a little bit less, they seem to be in a preset format. So we felt that it would be more appropriate to not charge a fee or any extra fee for the length of that document. But for non-patent literature, it can be almost of any size or any nature, and they tend to be a little harder to digest for examiners. And so after a while, it just takes more than your typical amount of time to read a long document, especially if it's not a patent document. And so we felt that it would be appropriate to recover that cost with the excess document size fee.
So we know you told us that fees were set under cost recovery, but can you help us understand what many perceive to be a hefty charge on supplemental? You've got 5 for the supplemental part. You've got 17 for the re-exam. It's 22 total. How did the office arrive at this fee? And, 17 seems like a big, big jump.
It is a big jump from, if you will, comparing it to our re-examination fee. The reason is that now that we have a CRU, and I think we've had one since 2005, we can pretty accurately capture what amount of time and money is spent in that unit to do re-examinations. And when you look at, the cost of that unit plus its overhead, and you divide that by the amount of work it output, you can pretty easily determine how much you have a cost per output. And it was apparent to us that our cost was much higher than our fee. So really the question is why we didn't adjust the fees earlier, not why it's so big now. And we felt that the process for supplemental examination, even as is provided for in the statute, is so close to ex parte re-examination that it was the best proxy, of our current processes to determine the appropriate fees for supplemental examination.
Well, I'm so glad you said just normal ex parte re-exam, because I also want to understand why did the fee for ex parte re-exam jump from $2,500 to almost, again, $18,000?
The problem here is that in the past few years, we have strongly suspected that our re-examination costs were not in alignment with that fees we charged, and we had been considering adjusting that fee. But now that we're doing a notice of proposed rulemaking and we are looking at those costs with the scrutiny you have to give to actually set a fee, namely the supplemental examination fee, it was very clear to us that our reexamination costs were much higher than the fees, and we felt that it was just not appropriate to have supplemental examination fees be so out of alignment with reexamination fees. So especially when there is a statutory mandate that when you know your costs are a certain amount, you should not be setting fees, so wildly different from that cost. I think, $2,200 versus $17,000.
So I know at least one person in the audience has a question about small entity discounts. So I'll ask that for you. Will the small and the micro entity discounts apply to supplemental exam fees?
Yes.
Will they also apply to the new re-exam fees?
The small will, the micro will for a patent owner requested reexamination.
I think we have a question on the right, a comment maybe?
Hi. Well, I have a question. Under the current rules for ex parte examination, it usually takes quite a while to get the process through. Under the new rules, do you expect the ex parte reexamination process to take a shorter amount of time?
We plan to make an effort to do these promptly.
And what do you have a timeline? Well, for example, the supplemental examination, you indicated would be completed within 3 months. And just looking at it from a litigation standpoint, if you want to file a lawsuit, this also might provide help you shore up your patent in your case. So I'm just curious, for the ex parte examination, about how long do you
I can't give you a set time frame, but it's hard to project. It depends upon what the ultimate rules will be.
Mm-hmm.
Sorry.
Do you think it'll be faster or a shorter time period if you would use the avenue of a supplemental examination, if of course you qualify?
As opposed to what?
As opposed to just filing the ex parte re-examination? Or do you now have to do the supplemental examination before? Maybe I'm misunderstanding.
Well, you don't. Well, first of all, you never have to do the supplemental examination. Mm-hmm. It's only if the patentee wants to come in to get the immunization. So if you want that inequitable conduct immunization, there would be no point to filing an ex parte, the regular ex parte request for reexamination. But I apologize. I'm just not able to guarantee exact time frames other than our goal is to do this promptly.
Sure. I just know these are going to be questions that our clients have already asked, how this is going to impact their litigation strategies.
Now, one thing I will say is that in the supplemental reexaminations, there isn't the patent owner statement time, and that takes up about 6 months of our ex parte reexamination time. So they should be faster. How much faster, I really couldn't tell you.
Okay, but maybe not if it kicks into the ex parte re-exam. If you
that is part of in an ex parte re-exam that results from a supplemental exam, there's no patent owner statement before the first office action, so we should be able to get that out faster.
Okay, and then I just have 2 other real short questions relating to this. When do you anticipate these rules taking effect, the new ex parte examination rules as well as the supplemental rules? I know we have this process to go through, but do you have about a ballpark time period?
Sure. Well, for the supplemental examination, I'm pretty confident they'll go into effect on September 16th of 2012, or I won't be here. As far as the ex parte reexamination fees, I would estimate they would probably go into effect at about the same time, since they're in the same package. They wouldn't have to go into effect on the same date, but they wouldn't be off by months.
Okay. All right. Thank you very much.
If I can add quickly just on the timing issue and how quickly we will get these completed. One of the issues we're struggling with is what we're hearing about usage, and we're hearing some people, like a comment was made today, that this may not be used a lot, and we're hearing from other people that this is going to be used a great deal. So it's just balancing workloads and what comes in. This is an entirely new process.
Well, I think from the litigation community, I think they're afraid that this will, or not afraid, but this will be a larger forum as opposed to addressing these issues in the district court. So I think our clients are having a lot of questions. So I really appreciate your answers. Thank you.
We have a question from our web audience. It pertains to ex parte reexamination, and the questioner would like to know why the PTO is proposing to change the standard from an anonymous submission to requiring the submitter to identify himself as the real party in interest.
I think this is the provision related to, now there are these estoppel provisions where if a party has requested a inter-parties review or post-grant review on a particular claim of a patent and there's a final decision in that proceeding, they can't come in thereafter and request or maintain an ex parte reexamination. So now there is a reason why we would need to know that the party is not estopped and that the party has the ability to maintain it if there is a decision in a inter-parties review or post-grant review.
Yes, sir, on the left.
Is there anything in the rules that prevents a patent owner, once there's been an ex parte re-exam, to request a supplemental examination, so thereby effectively preclude the re-examination requester from the process?
I think his question is if the patent owner...
Okay, you have a regular ex parte re-exam, I'm assuming started by a third party.
Right.
And at which point they should be out of the process once you get to the first action stage.
Right, but is it somebody effectively now asks for supplemental?
They would
not the original supplemental request, but now that they can't participate at all, they're not going to get copies?
Well, they could not participate. They would not be in the supplemental examination process, but they could still be in their ex parte to the extent that they were permitted under the current rule.
Right, so they'd still be a part, presumably that would still carry over.
Right. They would still get that information.
Okay.
But exactly how we would handle two parallel proceedings, we haven't worked out the details of that.
A question on the left.
I'm a little confused about the fees for supplemental examination, the $5,000 and $16,000 fees that you've shown today. But I thought there was another rulemaking a few days since that said these would be like $7,000 and $20,000. So what's being proposed?
Both in a way. For the rules to just get the supplemental examination process up and running on September 16th of this year, we're proposing the fees are in the $5,000 and $16,000 range. Those are the cost recovery levels that we project for that activity. The other proposal was the Section 10 rulemaking, the provision where we can set fees that are not tied to costs, and just so that all the revenue equals all of our costs. And the $7,000 and $21,000 proposal was part of that proposal. That would not take effect. I'm borrowing some mirror. That's looking more like March 2013, where that would take effect. If we proposed, we haven't even published a notice of proposed rulemaking yet for that. So if that was proposed and if that was made final, that's what the fees would be under that rulemaking.
Okay, thank you.
Question on the left or comment?
Just a quick point of clarification on the question that was raised about you have a third-party request or ex parte re-exam that's been filed, maybe you're waiting order, maybe it's already been ordered, and the patent owner now comes in and files under supplemental examination, and lo and behold, a piece of information in that supplemental examination request is deemed to present an SNQ. And let's say that is, for example, an alleged prior use and sale. If you then order re-examination in that proceeding, I got an implication in your answer before that you probably could not and would not merge the two pending ex parte re-examination proceedings, because in the requester proceeding, as filed, public use and sale would not be a valid basis for conducting re-examination.
In answer to your question, I don't see those proceedings getting merged for practical reasons that you point out.
Okay, thank you.
I'm going to interject here one moment. We have a follow-up comment from our webcast audience to this question about identifying the person who's filing for the ex parte re-examination. The commenter would like to share that it should be enough for the party submitting a re-examination request to attest that this is their first re-exam filing, and then there wouldn't be the estoppel considerations that you had explained. So that's something we should take into consideration when we're building our final rules. And then another comment from the webcast audience is, would it not be sufficient to simply require a statement that the re-exam requester has not conducted any of the activities that raise an estoppel against filing of a re-exam?
Thanks. I mean, those comments should be submitted in response to the notice of proposed rulemaking. We will certainly take those into consideration.
Question or comment on the left?
Nancy Link, Alexandria, Virginia, and I'd like to initially commend the PTO for a really excellent job of pulling together all these rule packages in a timely fashion and for educating us, so thank you for that. On the items of information, I think the description, however, is a little less than clear as to what an item of information is, and I'm wondering if it would make more sense to base it on issues raised. You have 10 issues raised. Also, one issue could involve 3 items of information, for instance, on 103 issues. So while you say 10 is a lot, it may not be a lot, and you talk in terms of issues throughout the rules. So I would maybe it's something you already thought of, but I would recommend you consider talking about number of issues raised rather than items of information.
Thanks. And obviously, this is a proposal for comment, and those are a good comment that maybe we focus on issues and maybe, we ask whether or not 10 is the right number. But certainly we're open to comments.
And I will submit written
thank you.
comment. Thank you.
Any more questions or comments from our webcast or live audience? Well, you've all been a good audience, so I'm going to let you out 5 minutes early for lunch. So let's come back at 1:30, and we will begin our discussion of the contested case provisions.